Most of you are doubtless familiar with the phrase innocent until proven guilty, but what if that were to be reversed sometimes? Guilty until proven innocent, because sometimes that is indeed the case. So welcome back to my channel, but if you're new to me, I'm a barrister who helps you understand law. And in this case, talking about certain situations that some people might find grossly unfair, but are nonetheless true. So I bring this up because one or two of my videos just recently have been talking about things that come under this category. For example, parking fines, speeding fines, driving without insurance. All of these things are what we refer to as a strict liability, meaning it doesn't necessarily matter whether you had the necessary train of thought, or mens rea as it's known in law, the intention to do something in respect of a particular act, or actus reus as we call it in law. So in other words, you can be guilty of something without even meaning to do it. And there are some fairly strict examples of this. Take, for example, the possession of a restricted drug. You might well know that you are in possession of a substance, but you may not know that it is a restricted substance. But nonetheless, if it is proven that you are in possession of that substance and that substance is illegal at the requisite time, even if you didn't know what it was, but you know that you had it with you, you will likely be found guilty of possession of that drug under the relevant legislation. And if you don't mind me interrupting the flow for just a moment, I'd like to ask for your support. I get a lot of emails asking me to do videos on family cases, family law, and asking me all sorts of specific questions, but many of which those videos simply won't get promoted on the YouTube algorithm, partly because of the content and so on. But if you would like to see more of those videos and ask very specific questions, I'm happy to do those videos over on my website, blackbeltbarrister.com, where you can access those videos on a subscription service, but in support of me doing those videos at your request. The discount code that you will see on screen will tell me that you are doing it in support of this venture, and you can enter Black Belt Support as a coupon code to get access to all of the exclusive videos on that website. Between now and Christmas, and in the spirit of the Black Friday discounts, anyone that signs up between now and Christmas will get access to every video on that site for just $9.99 as against the usual subscription price. So if you'd like to support me just generally, and if you'd like to ask for specific videos like those that don't really do well on the YouTube platform, then head over there, use that discount code, and I will be extremely grateful. Thank you, and back to the video. And this happens in civil cases as well. For example, in defamation. If somebody makes a statement which is false and it causes serious harm to reputation or serious harm in respect of a business profits, then there is a presumption in law that the defamatory statement is false, and the burden of proof is reversed onto the defendant who made the statement. In other words, one possible defence is that the statement was substantially true. But in England and Wales, the burden of proof is upon that defendant to prove, if they are running with a truth defence, that the statement made was indeed substantially true. Not necessarily completely 100% true, but substantially true in the essence of what it was saying. The same can be said for many health and safety regulations for businesses, because it's only right that if a business has breached health and safety regulations, whether knowingly or not, because a company itself obviously cannot know or not know something. It's only really the controlling mind in the directors of the company or the person in substantial control of the company that might have said knowledge. However, if the company has breached these regulations, regardless of any knowledge, then it's breached the regulations, and those regulations are there for a reason. So many of those, it is only right that they are strict liability. If the business is in breach of one of those regulations, it does give rise to potential damages claims by some injured party. There is also, to a lesser extent, a reverse burden of proof in many criminal cases where somebody, let's say for example, raises the defence of self-defence. If you have hurt somebody and you are being prosecuted for assault or even worse, it is a potential defence to you to raise self-defence as your defence. And the burden is indeed upon the defence to raise this defence, but then the burden shifts back to the prosecution to disprove that defence. But it's the standard of this burden of proof that differs. You see, a defendant is never required to prove something beyond a reasonable doubt, only on the balance of probabilities, whereas the prosecution prosecuting a case against said defendant must prove or disprove something, as the case might be, beyond a reasonable doubt. In a case of self-defence, the prosecution must rebut the defence of self-defence to a standard beyond the reasonable doubt, or so that the jury is sure that the defendant was not acting in self-defense, and then self-defense has its own test. In fact, there are two parts to that test. Very broadly speaking, what the defendant believed was genuinely the case at the time and the circumstances called for the use of force in self-defense, and then objectively, does the jury, or indeed a magistrate if it is being heard at the magistrate's court, do they consider that the force used objectively was reasonable in the circumstances given the genuine belief put forward by the defendant? And so coming back to things such as parking fines, not parking charge notices, which I'll come back to in a moment and I've dealt with in many videos, but parking fines as in penalty charge notices and speeding fines and red light fines and red line fines and all of these kind of things, they are deemed to be strict liability because that has occurred. So unless there is an exceptional circumstance that you can use in your defence, which the burden upon you is to prove, then the strict liability means that you are going to be strictly liable to that offence. So in essence, as unfair as it might sound, the strict liability nature of a speeding offence means that you are liable for that speeding offence unless you can show somehow that the information or the charge was defective. For example, if you could show that the information on the NIP, the Notice of Intended Prosecution, was somehow defective, that might serve as some kind of defence for you. Equally, if you can prove that you were not the driver of the vehicle at the time, that might also raise a proper defence. You might also argue that the speed of the vehicle had been incorrectly identified, or the signs on the road were incorrect or misleading, or simply that the camera was not authorised, not validated, or any of these kind of things. But these, in all reality, are somewhat rare. Although if you do get a lawyer who is a specialist in this field and can explore each of these avenues, those might be a defence. But it doesn't detract from the fact that this is a reverse burden of proof. It's a strict liability offence. The offence of speeding requires only a couple of things. One, that you are driving a motor vehicle on a road or public place and that it is exceeding a speed set by regulations or other legislation. So this is why, and just to emphasise the point that I said in my video of this morning, if you receive something through the post, whether it's a claim, whether it's a fine, whether it's a notice of intended prosecution, you absolutely must not ignore it, especially if it's one of these things that might well be a strict liability situation, whether civil or criminal in nature. You're always best to seek advice to determine the exact nature of what it is that you've received through the post. If it is a strict liability or if it's a claim in court, you shouldn't ignore it, because almost always, if not always, it's going to be very much worse if you ignore the situation. I said I would come back to parking charge notices. This is perhaps one exception, even though you shouldn't ignore it still, but these cannot be an offence of sorts because a private company cannot fine you. It isn't a fine as they are often referred to in the newspapers. People often, as I read yesterday morning, some lady drove through a fast food outlet and bought a muffin, only to be given a £100 fine as it was put in the article thereafter. However, on looking at the photographs in the article, it very much looked like it was a parking company managing the parking for a particular premises and not a local authority, in which case it's a parking charge notice, not a penalty charge notice, therefore not a fine as it's often referred to in the papers. Although very often you will receive a yellow slip thinking that it's a fine, thinking that you have to pay it because it's a fine, but the truth of the matter is, in order to enforce a parking charge notice, the company would have to take you to court. That's still not to say that you should ignore it, and still not to say that you should fight it if you actually were caught in breach. There are appeals processes. I would always recommend you go through those first, but ultimately if you do want to fight it and it's a parking charge notice, not a penalty, then they would have to take you to court for enforcement. I've got many playlists for those. I've linked in the description below. Please check those out. Also, please do remember to like this video and subscribe, and as always, thank you for joining me.